IVM.
So welcome to another week on IVM. If you aren't following us on social media, please do. We're IVM Podcast on Twitter, Facebook, and Instagram. This week on Simplified in a Shorty, Naren and Shrikant simplify the phenomena of near-death experiences with interesting cases and scientific theories. On Pragati, Pawan and Hamsani are joined by economic policy expert Yazad Jal to discuss negative and positive rights. On the scene and the unseen, Amit Verma is joined by stand-up comedian Aditi Mittal and our production controller Swati to discuss misogyny and popular culture. On Pulyabazi, Saurabh and Pranay speak to Shruti Rajgopalan about the meaning and importance of property rights in India. This week on Shunya One, we have Suchita Salwan, founder and CEO of LBP, a local recommendations platform striving to discover all things new and old. On Hustle Science, Ranveer and Tejaswan speak to their buddy, tech entrepreneur and founder of Hello Inc., Angad Nadkarni, to understand his coding craze and a lot more about his stories. And now, on to your shows.
Hi,
You're
listening to IVM
Daily. Hello and welcome to IVM Daily, the home pitch for IVM staff members where we discuss ideas, issues and current affairs. And today I'm talking alone to you because there is no one in the office due to rains. Today we are trying to understand whether death penalty can really serve as a deterrent for sexual crime against women. And the need to discuss this is triggered by the Supreme Court's decision to reject petition filed by the 2012 Delhi gang rape convicts to review the death penalty given to them. So this is the case, and I just want to remind you of a 23-year-old paramedical student who was assaulted and raped by 6 men on the intervening night of December 16th and 17th in 2012. And this incident happened inside a moving bus in South Delhi. So she died on December 29th, 2012 at Mount Elizabeth Hospital in Singapore. Another accused in the case, Ram Singh, died in Tihar jail, and convicted juvenile was released from the Reformation Home after serving a 3-year term as per the Juvenile Justice Act. So this case was very crucial and is very crucial in the legal history of India as well, because this case led to the amendment of the Criminal Procedure Code to make rape punishable with death penalty. In its May 2017 judgment, the court had concluded that the convicts, and I quote, found an object for enjoyment in her, for their sadistic and beastly pleasures, for the devilish manner in which they played with her dignity and identity is inhumane. So to talk about the Supreme Court's latest decision on the review petition, I am now joined by Abhay Turkar from Delhi, who is a Supreme Court lawyer. Welcome, Abhay.
Yes.
So you must have seen the reports in newspapers and the decision that has come from the Supreme Court to dismiss the review petition. A few activists have been saying that a message needs to be sent across the society, and this judgment has done that.
Yes.
Do you also think that this is really a message that justice can be served through capital punishment? Do you think that this judgment in any case sends a message?
Well, I think the message was sent right at the beginning when the Sessions Court had awarded the punishment, upheld by the Delhi High Court and upheld by the Supreme Court in the criminal appeal also. Now, the way the review petition functions is that it doesn't really go back into the merits of the matter in its entirety. The review petition is a much smaller jurisdiction. So I think the message was sent by the Supreme Court when it passed the first order dismissing the criminal appeal. And I believe it was Justice Bhanumati who was one of the judges on the bench. It was the bench comprised of Chief Justice Deepak Mishra, who at that time wasn't the Chief Justice, Justice Ashok Bhushan and Justice Bhanumati. And Justice Bhanumati has passed a very scathing judgment. If you happen to read that, you will see. So that judgment certainly sends a very strong message out in the society. Upholding the capital punishment.
But are the convicts still left with any other legal remedy? Is there any remedy available to them even now?
Well, there is. So there are possibly 2 or 3 remedies that which are available to them.
Okay.
One being filing a curative petition. A curative petition does not find its place in any law or any statute. It is something that the Supreme Court has devised for itself. By using a very broad term saying to ensure that there is no miscarriage of justice. Now, the reason why the curative petition exists is because unlike this case, where the review petition was heard in an open court, where arguments were made, considered, arguments were answered by the prosecution. In many cases, the review petitions are decided in the chamber by simply reading what the submissions have been made. So there is an option of filing a curative petition. Before filing that, they would have to point out, when I say they, I mean the convicts, they would have to point out what is the miscarriage of justice which has been done.
Okay.
They would also need a certificate from a designated senior advocate who would say that this is a case fit for a curative petition.
Okay.
If at all they are able to cross these two hurdles, then as I understand it, this matter would, the curative petition would be placed before the three senior-most judges of the Supreme Court, along with those judges who had decided the matter, and then perhaps it may be heard again. But in the facts of this case, it is unlikely that a curative petition will be entertained. That is one option.
Okay.
The other option, of course, is to file a mercy petition before the president.
Okay.
But that is beyond the scope of the judiciary. That will be decided by the president while exercising his constitutional powers, of course, with the aid and advice of the Central Council of Ministers. And let's proceed on the assumption that the president does not pardon them, in which case there is a very nascent line of judgments which say that the decision of the president refusing to pardon can also be challenged before the Supreme Court.
Okay.
If I'm not mistaken, something like that was done in the case of Afzal Guru.
Afzal Guru, yes.
Yeah. But that jurisprudence is at a very basic stage. So whether they can do that, and especially in the facts and circumstances of this case, would the Supreme Court really, having once decided that they deserve to go to the gallows, would it interfere? I would assume it would not.
Okay, so
but these are really the only options available.
Yeah, so just for the benefit of our listeners, if you could just explain that this curative petition, which is one of the remedies as you mentioned, so the convicts have to show that there was a kind of judicial bias against them. That is when, So what kind of bias can they show if there is any possibility?
Well, in this case, on the facts of this case, it's very unlikely that they will be able to establish bias. Now, like I said, the term that the Supreme Court often uses is miscarriage of justice. Miscarriage of justice is an extremely wide term.
Yes.
It encompasses within itself things like judicial bias, things like not following principles of natural justice, not giving someone an opportunity of being heard. Now, these have to be really established in a curative petition.
Okay.
In the present case, after going through the entire process, all the way from the Sessions Court up to the Supreme Court, even once the Supreme Court having heard the review petition in open court, which is very rare occurrence. Like I said, review petitions are usually decided in chamber, and lawyers are not allowed to put forth their submissions except for the written submissions which are mentioned in the review petition.
All right.
So in this case, it would be very unlikely for them to be able to establish any sort of bias, any sort of miscarriage of justice. Okay. So they're on a very slippery wicket there, if you ask me.
So, lastly, I would want to ask you, what is your own take on this as a practitioner, as a lawyer? Do we need death penalty as a corrective measure, as a weapon to serve justice, or should we just do away with it now? Do you think it plays a kind of deterrent to crimes like sexual crime or any other, heinous crime?
If you ask me, at some point, we need to do away with the death penalty. That's my personal opinion. But is that time now? Perhaps not. The reason why I say this is because Western countries which have done away with death penalty have relied on academic papers, on statistics which indicate that death penalty is not really a deterrent. But the Supreme Court in India has carved out sort of a midway by laying down the rarest of the rare case test, where death penalty is awarded only in cases which are rarest of the rare. So although let's say for a murder, the maximum penalty which can be awarded is the death penalty. But it's not a nice thing to say, but if it's a routine sort of a murder, then the death penalty would not be awarded.
Right.
Take the case of something like terrorism acts, or even this Nirbhaya case that we're talking about. It is something that shakes the conscience of the society.
Yeah.
And if it shakes the conscience of the society, the Supreme Court says that the convict must be hanged to death. So I think for the time being, the kind of society that we are, it perhaps may be acting as a deterrent. An academic who probably studied this, who has statistics, may be able to establish with empirical data whether it actually acts as a deterrent or not. The flip side being, I mean, I haven't come across any case in India, but we've always heard of cases in the United States where people have been convicted on racial basis, have been awarded the death penalty, and years down the line when that matter goes up in appeal, you find out that they ought to have been acquitted. So that's something that perhaps the legislature may consider when
and I think this country,
decide whether or not we should have it.
Being a democracy, it needs to have a wider debate before it reaches on any kind of conclusion for that.
Yeah, right. I would agree with that. I don't think as a society, I don't think we are ready to abolish it just yet.
Okay, Abhay. Thank you so much for joining in.
My pleasure.
Thank you. Thank you. So that was Abhay Anturkar, a Supreme Court lawyer who believes that India as a society is not ready to abolish capital punishment, and there is a need for a wider debate to happen about capital punishment as a reformative measure to serve justice. On that note, it's time for me to say bye-bye, but stay tuned to IVM podcasts. We are available on all social media platforms, and you can follow me on Twitter. My handle is SwatiBakshi02. Till we meet next, bye-bye.
Hey, what's good, you guys? It's your boy Ranveer Alabadia from the YouTube channel Beer Biceps, and the Beer Biceps team is bringing you Hustle Science. Hustle Science is basically a show where we interview hustlers. We ask them about what made them legendary. We ask them about their success secrets. We go to the core of their legendary status in life. It's going to be hosted by my boy Tejaswin Gumber and yours truly, Ranveer Alabadia. Make sure you catch Hustle Science on the IVM podcasting app and website, or any kind of podcasting platform that you use to get your podcasts. Make sure you check it out. The episodes are going to be out every single Tuesday.
Shunyavan, 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 Shunyavan.
$1 billion acquisition. Another copycat startup got formed.
No, the tech world in India is surely moving double the speed of this voiceover.
Tune in to Shunya One every Tuesday to catch us talking to the smartest people we know on the IVM Podcast website, app, or wherever you get your podcasts from.